Hello everyone, this is lecture 8 on the Supreme Court Rules 2013. In this video, we are discussing Order 7, which provides for proceedings by or against minors or persons of unsound mind. There are total 13 rules. Let's begin. Before starting, let's see who is a next friend. So a next friend is any person who has attained majority and is in some way related to the minor so as to ascertain his or her interests. Now come to Rule 1. Rule 1 provides that every appeal, petition or other proceedings by a minor shall be instituted or continued. Instituted or continued in his name by his next friend. So it means if I, being a minor, want to file an appeal, file a petition or any other proceeding against someone, I cannot institute it myself or I cannot continue it myself. I will require a next friend to do that on my behalf. There is an explanation attached to it. It explains who is a minor. It simply directs that a person who has not attained his majority within the meaning of Section 3 of Indian Majority Act is minor. We all know that Indian Majority Act is a very small act and it actually has only 3 sections, and its Section 3 provides that any person who is under the age of 18 years, who has not completed age of 18 years, will be a minor. What is Rule 2? I, as a next friend, want to retire from this case. I don't want to help my minor friend. Can I leave? No, you will not be allowed to retire. You will be permitted to retire only with the leave of the court. And even after that, the court may require you, Mr. Next Friend, to procure a fit person to be put in his place before he is permitted to retire, and may also, if it thinks fit, require him to furnish security for costs already incurred or likely to be incurred as a condition of his retirement. Rule 3, it has 2 sub-rules. Sub-rule 1 provides that on the retirement, removal or death of the next friend of a minor, further proceedings shall be stayed until the appointment of a new next friend in his place. I am a minor. A proceeding was instituted, a proceeding was continued on my behalf by my next friend. My next friend has retired from this, or he has been removed by the court, or he has died. Now what? As soon as these 3 conditions come into play, the proceedings of the particular case will be stayed. Stayed till when? Stayed till when? Stayed until fresh appointment. Unless a new next friend is appointed, till then the proceedings of this case will be stayed. What is sub-rule 2? Where the advocate on record of such minor omits within a reasonable time to take steps to get a next friend appointed, any person interested in the minor or in the matter in issue may apply to the court for the appointment of one, and the court may appoint such person as it thinks fit as the next friend of such minor. I am an advocate on record for this minor. I have omitted to take steps. The earlier next friend has retired, removed or died. I have omitted to take steps to get a next friend. Now what? Any person interested may apply. That's what is Rule 4. An application for the appointment of new next friend of a minor shall be supported by an affidavit showing that the person proposed is a fit and proper person to be so appointed and has no interest adverse to that of the minor. So see, this Rule 2, Rule 3, Sub-rule 1, Sub-rule 2, they provide a condition when the next friend has been removed, retired or has died. So obviously a new appointment will be made. So Rule 4 provides that when this application is made by the advocate on record or by any other person interested, that appointment will be made only if this application is supported with an affidavit. What is Rule 5? See, Rule 5 is for a minor who is respondent in the case, meaning thereby that I have filed a case against you. You are a minor, means you are a respondent. So there is some duty which has been cast upon me. So where a respondent to an appeal or petition is a minor and is not represented by a guardian, an application shall be made to the court by the appellant or petitioner, as the case may be, or by some other person interested in the minor for the appointment of a guardian of such minor. And it shall be supported by an affidavit stating that the proposed guardian has no interest in the matter in question in the appeal or petition adverse to that of the minor. What is Rule 5? Simply remember that Rule 5 relates to a minor who has been brought as a respondent, means against whom a case has been instituted. Now that minor is not represented by any guardian. So it will be duty of the petitioner, appellant or some other person interested to make an application before the court for appointment of guardian. Who can be made guardian? Well, father. If there is no father, then mother. If there is no mother, then a person with whom that minor has resided in the last 14 days. What if that person is also not found? Court may also appoint any officer of the court to be a guardian of that minor. What else? Court may directly notice to the minor itself. This is all in Rule 5. Now what is Rule 6? Rule 6 has two subclauses. Subclause 1 provides that no guardian of a minor shall retire from a suit, appeal or other proceedings without the leave of the court. Mr. Guardian, you want to retire? No, you cannot retire unless the court grants you leave to do that. And where a guardian of a minor fails to do his duty or other sufficient cause is shown for his removal, the court may remove him from the guardianship of the minor and make such order as to cost as it thinks fit. So Rule 6, Sub-Rule 1 provides for two things. Firstly, that Mr. Guardian, you will not be allowed to retire unless the court permits you to. And secondly, power to remove the guardian appointed. If I am a guardian of a minor and court finds that I have failed to do my duties or any other sufficient cause is shown for my removal, court may remove me from the guardianship. What is Sub-Rule 2? Where the guardian of a minor retires, dies, or is removed by the court during the pendency of the suit, appeal, or other proceedings, the court shall appoint a new guardian in its place. So Sub-Rule 2 provides that the guardian has retired, has died, or has been removed under Sub-Rule 1. Then court will appoint a new one. Now let's see what is Rule 7. Rule 7 is in respect of a guardian ad litem of a minor respondent. Rule 5 was also about respondent minor. Rule 7 is also about respondent minor. Now I am a guardian ad litem of a minor who is a respondent in the case. And it appears to the court, or it is made appear to the court, that I, guardian ad litem, has no sufficient funds for the conduct of this appeal petition on behalf of the respondent minor. And because of this, there will be prejudice in his defense. Then in that case, the court may order the appellant or petitioner to advance money. So we can clearly see that Rule 5 and Rule 7 both protects the right of a respondent minor and casts a duty upon the petitioner appellant. Alright, you have filed a case against the minor. Alright, now these things you will have to assure. Now what is Rule 8? An application to declare as a major a party to a proceeding described as a minor and to discharge his next friend or guardian shall be supported by an affidavit stating the age of the alleged major and the date on which he attained majority. And notice of such application shall be given to the next friend or guardian and the alleged major. Now see, I had filed a case against you. On the date of filing, you were a minor. And for that reason, I had to go through all these procedures which a minor requires. Now today, you have attained majority. You are 18-year-old. Now I will move an application under Rule 8 of Order 7 to declare you as a major. When I am making this application, this will be supported by an affidavit clearly stating the age of the alleged major and the date on which he attained majority. And notice of this application shall be given to the next friend or guardian of the alleged major. What is Rule 9? Next friend or guardian of a minor has not to enter into any agreement or compromise on behalf of a minor. If you want to enter into any agreement or compromise, Mr. Next Friend or Mr. Guardian, you will have to take express permission of the court. See, what does it provide? No next friend or guardian of a minor in an appeal or other proceeding shall, without the leave of the court, expressly recorded in the proceedings, enter into any agreement or compromise on behalf of a minor with reference to the appeal or proceeding in which he acts as a natural guardian, in which he acts as next friend or guardian. What is Rule 10? In short, application under Rule 9, how made and benefit of the minor. I am moving an application under Rule 9 means I am a next friend or I am a guardian of the minor. I want to enter into any agreement or compromise. Now I am making an application for express permission of the court. So Rule 10 prescribes the procedure therefore. Let's read. An application made to the court for leave to enter into an agreement or compromise or for the withdrawal of any appeal or other proceedings in pursuance of a compromise on behalf of a minor shall be supported by an affidavit from the next friend or guardian of the minor stating that the agreement or compromise is for the benefit of the minor. This is the key word. The agreement in which I am entering into or the compromise which I am making with is for the benefit of the minor. And where the minor is represented by an advocate, by a certificate or by a statement at the bar from such advocate to the effect that the agreement or compromise is, in his opinion, for the benefit of the minor. A decree or order made in pursuance of the compromise of an appeal or other proceedings to which a minor is party shall recite the sanction of the court thereto and shall set out the term of the compromise. So this application has to be supported by an affidavit, and the main concern of the legislation is to assure that there is benefit to the minor. Now what's Rule 11? Rule 11 has two sub-rules. Sub-rule 1 provides that no decree passed against a minor shall be set aside if next friend or the guardian of the minor has interest therein, though such decree may be set aside if prejudice to the interest of minor is shown. Now let's come to Rule 11. It has two sub-rules. Sub-rule 1. No decree passed against a minor shall be set aside merely on the ground that the next friend or guardian for the appeal, petition or other proceedings of the minor had an interest in the subject matter of the appeal, petition or other proceedings adverse to that of the minor. But the fact that by reason of such adverse interest of the next friend or guardian for the appeal, petition or other proceeding, prejudice has been caused to the interest of a minor shall be ground for setting aside the decree. So Rule 11 Sub-Rule 1 provides that, see, I am a next friend or guardian of the minor. Now there was a case which was instituted against the minor and I was pursuing it on his behalf. What happened is that a decree has been passed against me, the minor. So Sub-Rule 1 provides that minor lost a case. A decree has been passed against him. Now that decree is going to be challenged and a prayer for setting aside of the same is being made on the ground that the next friend or the guardian who was pursuing the case had an interest in the property, had the interest in the subject matter of that case. Can it be a ground? No. That decree will not be set aside on this ground. But yes, if you can prove somehow that by reason of such adverse interest of the next friend or guardian for the appeal, petition or other proceeding, prejudice has been caused to the interest of the minor, then it shall be a good ground for setting aside the decree. Simply saying that the next friend or the guardian had an interest would not make it a case for setting aside a decree. But what if I show that this adverse interest has caused prejudice to the interest of minor? Then it will be a good case for setting aside the decree. It will be a good ground for doing that. What is Sub-Rule 2? Nothing in this rule shall preclude the minor from obtaining any relief from this court available under any law by reason of the misconduct or gross negligence on the part of the next friend or guardian for the appeal, petition or other proceeding resulting in the prejudice to the interest of the minor. My next friend, my guardian, have done a misconduct or negligence, and this misconduct or negligence has caused prejudice to the interest of minor. Well, then nothing shall preclude the minor from obtaining relief from this court. Rule 12. The provisions of this order, so far as they are applicable, shall apply to persons adjudged to be of unsound mind and to persons who, though not so adjudged, are found by the court on inquiry by reason of unsoundness of mind or mental infirmity to be incapable of protecting their interest when suing or being sued. So Rule 12 provides that if I am a person of unsound mind or I am a person incapable of protecting my interest, then the provisions of this Order 7, which are basically in respect of the minor, shall apply to me as well. What is Rule 13? Save as aforesaid, the provisions of Order 32 of the Code relating to suits, so far as applicable, shall apply mutatis mutandis to appeals and other proceedings in the court. So this is it. Please like, share and subscribe to our channel, and thank you for watching.